Working on behalf of Mr. Mahon, party plaintiffs. Mr. Mahon is with me and Mr. Caloiaro.
Good morning, Your Honor. Again, Rory Kay and John Porter McDonald Toronto on behalf of the Spin Games defendants in this matter. Good morning, Your Honor. Steven Caloiaro on behalf of Bragg parties from Dixon, right?
Morning, Your Honor. Jeff Hewlett on behalf of Full Color Games, Inc.
Good morning. All right, I've got what appear to be basically duplicative motions, correct?
I think it's
Kent Young et al. Motion to dismiss and Bragg parties motion to dismiss. Both motions are being made pursuant to NRCP 41E2B, correct?
correct, Your Honor. Rory Kay for the Spin defendants. Our motion is on behalf of 41E in the component with respect to the 5-year rule. I believe Mr. Caloiaro also made an argument under the discretionary 2-year portion of that rule. And there are some unique service issues that were raised in the opposition that only deal with his clients. And so our thought was I would take us through some of the issues and then turn the service issues over to him with respect to that portion of his motion to dismiss and the opposition responding to the same.
Go ahead.
Thank you, Your Honor. Again, Rory Kay for the Spin defendants. I will tell you, I'm going to argue 2 motions to dismiss in front of you today in different cases, and they're in far different procedural postures. Usually when we come in front of Your Honor, you have discretion as to what you do with the issues in front of you. This is one of the rare points, however, where there is no discretion under Rule 41E for dismissal under the 5-year rule. This is a case, as you are well aware, it has been pending since August of 2017. The underlying facts and occurrences date all the way back to March of 2016. In this case, this dismissal is really a matter of math. Did the plaintiffs try their action under the 5-year rule before the expiration of the 5-year deadline? Here the answer is unequivocally no. If we just run the straight math from August of 2017, my clients came into the case in February of 2019. Mr. Caloiaro's clients came into the case in January of 2020. But for that wonderful COVID pandemic, the 5-year deadline would have expired in August of 2022. The full color parties argue that there are 472 days where that deadline was told because of the COVID pandemic. I haven't been able to find any controlling authority on that point from the Nevada Supreme Court, but we don't dispute that for the purposes of the 5-year rule. We're fine with the court adding on the 472 days to the original deadline of August 2022. That brings the 5-year deadline to November of 2023. We also had the recent Nevada Supreme Court stay that took the deadline to April of 2024. That was by virtue of the writ petition that they filed. The Supreme Court stayed the case down here while it disposed of that writ petition. It ultimately denied the full color parties writ petition. And so we have a 5-year deadline that expired in April 8th, 2024. Full color parties obviously have not tried it by this point in time. And so the rule mandates dismissal. Now they try and save that.
You're seeking dismissal with prejudice, right?
We are, and that's
which brings me to the question: what's the status of the other case that was originally, I think, before Judge Gall, and I think it went to Judge Escobar? Of course, Judge Escobar is no longer here, so where is that case?
It's in the judicial assignment rodeo, Your Honor. It started with Judge Alf, and then when she retired, it got reassigned to Judge Gall, and it's been shuffled around since then. It's stayed right now. It was stayed originally. We had moved to dismiss there, and Judge Alf said that she wanted to see both what the Supreme Court would do with the writ petition and what Your Honor did with the case in your department. And so as of right now, it was stayed. There was supposed to be a status check, I think, a month and a half ago. We didn't have a judicial assignment yet, and so that got kicked out a few months. I think that department is waiting to decide what this court does. It's still in pending status. We haven't filed a responsive pleading. Depending on what Your Honor does here, we may move to dismiss that action as well, but at least for the purposes of this argument, it is still a pending case. I will tell you there are a couple things. When we look at the Monroe factors on dismissal with or without prejudice, ultimately the core of them gets to whether the plaintiffs have had adequate time to try their case in the 5 years. If they haven't, occasionally, and this is an area where you do have some limited discretion, district courts will allow them to refile, dismiss without prejudice so that they can refile. I don't think this case is. My clients have been in the case since February of 2019. The full color parties have had since that point 5 years to litigate their case. They haven't done so. There's no need to dismiss without prejudice or to invoke that exception. Frankly, they can't show the factual predicates to receive that sort of dismissal. The other thing just for the record, I know they took a writ petition up, and so I want to be clear on establishing my record to the extent we have to do so again. They invoked this Boren case. We filed a reply this weekend, Your Honor. My apologies. We're here on an order shortening time, and so we had to file it Saturday. Boren doesn't help them out in 3 independent respects here. One, Boren is a case that involved a stay that was obtained by the defendant. Therefore, to avoid the injustice of a defendant stay in a case, the Boren court created an exception to the 5-year deadline that says, to the extent a case is stayed because of factors outside of the plaintiff's control, the plaintiff is not held to the strict deadline of the 5-year rule. That doesn't help them here. They moved discretionarily to stay their own case back in 2021. You may recall, Mr. Caloiaro and I had pending motions to compel document productions at that time. Within a couple of weeks, they moved to stay their own case, and it was a stay of discovery. I know how they drafted the order as a generic stay of discovery. Practically speaking, it was a stay of discovery from the full color parties. The only discovery pending at the time they filed their motion to stay were discovery requests to the full color parties. In fact, when Your Honor lifted the stay in January of 2022, they waited 3 months to serve discovery on my clients. And I'll let Mr. Caloiaro talk about this more, but I think they waited almost a year to serve discovery on it. So the only thing that was stayed at the plaintiff's request was discovery from them. So they don't qualify under Boren for that reason. They also don't qualify under Boren because it wasn't a complete stay of the case. All of the cases after Boren talk about the idea that the stay must be complete as to the entire case. It must prevent the plaintiffs from trying their case. This stay obviously did not. The order which we cited to you was a stay of discovery. In fact, in the roughly 5 months the case was stayed, the full color parties continued to take litigation activities. They filed an amended complaint. They settled with certain third-party defendants, and Your Honor had related motion practice with respect to that. Nothing prevented them in that stay from taking the matter to trial. And mind you, again, that stay expired in January of 2022. We gave them several warnings. In fact, the original shareholder plaintiffs way back in 2019 gave them warnings about the 5-year rule and the need to move this case along. They didn't. They chose to name 38 some odd third-party defendants. They ran into service issues, I guess, with respect to some of them. They didn't timely serve others. Nothing in that stay prevented them from taking this matter to trial. It was a partial stay. It doesn't qualify under Boren. The third independent reason, Your Honor, and I'll let Mr. Caloiaro talk more about this, is that the product was a product of misinformation. Now, this is an open question under Nevada law. I don't believe there's one Nevada Supreme Court case that we cited to you in our reply that deals with this. I don't know that there is another Nevada Supreme Court case that we could find. There are certainly California cases that apply as persuasive but not binding authority that say if you obtain a stay as a plaintiff through misinformation or fraud upon the court, you're not entitled to the tolling benefit under Rule 41. And so with that, Your Honor, unless you have any specific questions for my client, I will just note for the record that the service issues, again, had nothing to do with my clients. My clients, all 3 of them, appeared in the case. I think we were served with third-party complaint in February of 2019. We moved to dismiss in front of Your Honor in April of 2019. There are no service issues. They were not waiting to serve my clients. We've been in this case for 5 years and in front of you quite often. So if you have any questions for me, I'm happy to answer them. Otherwise, I will turn it over to Mr. Caloiaro with respect to the unique aspects of his motion that are different.
Yes, okay.
Morning, Your Honors. Be brief and not tread ground that Mr. Kay has already so aptly covered. Your Honor, we've been here a number of times and we've talked about this case and getting to the merits of this case because it's been Mr. Kay and my position that there are no merits. That this case was a series of wild and outlandish allegations that were mainly aimed at trying to drive Bragg to a settlement. And that was the reason that they went and filed an amended complaint during the stay of discovery to sue essentially every company that has ever touched by anyone that had anything to do with Bragg, regardless of any actual involvement in the litigation whatsoever. The court aptly and correctly dismissed all but one of those parties because there's no jurisdiction. The original Bragg defendant and Onyx defendant accepted service way back in, I think it was 2021. They accepted service, right? They're located in Nevada. They had nexus. They accepted service. They were not content with that because, again, they would then have to get to the merits of their litigation, for which there are none. This case has been pending for 6.5 years in front of this court. There's never been any ounce of proof served. The complaint is still rife with inadequacies. Now we'll touch on quickly, things by saying Bragg has an NDA with their client. Bragg doesn't have an NDA, right? Claim 19, which we'll talk about quickly, says that Bragg violated their NDA and therefore there should be an injunction. There is no NDA. They've admitted that in discovery. So we've been here and now it's time. I think I used a buffet analogy. For the past 2.5 years, we've been saying, make them prosecute their case, make them prosecute their case. And they've refused to do so. I equated it to being at a buffet with a 2-hour time limit. And they kept filling their plates, and now they're stuck and they can't eat it. They can't eat all their plates, so they're gonna get charged for it. So now it's time to pay the bill. And the reality is that bill is dismissal with prejudice. To address the 2 points that Mr. Kay brought, first with respect to services, I quickly alluded to. The reason that it was so difficult for them is, one, I don't think they were diligent in doing that. You told them no more time and then they'd come back to you for more time. I think the second issue is because they sue people that have nothing to do with Nevada and are not in this forum. So of course, it's going to be hard to serve companies overseas in foreign jurisdictions that again have nothing to do with this litigation, nothing to do with this case. That's their own choosing. No one forced them to sue them. They decided they wanted to do that with specious at best grounds to bring them in the complaint in the first place. If they want to blame the fact of they're not able to bring their case because it took too long to serve people, they shouldn't have filed this lawsuit against those people in the first place. Or once they realized it was going to be difficult, they could have just withdrawn or dismissed that complaint. They choose not to do so. That's their own making and their own decision. The second issue, Your Honor, that I wanted to address is the stay. If you remember, we vehemently fought that stay. We said, no, we have discovery. We want to get to the merits, right? Because our point all along has been there are no merits. So the sooner we get to this, the sooner we can demonstrate that. We fought the stay that they vehemently sought to get, and they did it under a guise that Mr. Mahon was some sort of key witness in a complex federal investigation involving, and you kind of see the same story, right? Involving several agencies across the US and as well as overseas, and that he was so key to this investigation concerning criminal charges that were going to be eminently brought against the defendants in this case, that he couldn't possibly bother to turn over discovery because it would jeopardize the criminal investigation. And in doing so, we said, well, where's the proof of that? And he filed the subpoena request under seal, and not even under seal in camera. So myself or Mr. Kay couldn't review it. Finally, after about 3 months and another status report saying, oh, there's a second subpoena, oh, the complaint for criminal charges is forthcoming, the court finally allowed us to see it. We had to come here in person to see it. And that's when we first got the name of the AUSA. Within 2 days, I called the AUSA and said, hey, can you give me any background on this? He said, this is not at all what I understood to be the case. This is not all I had. And within 5 minutes of me getting off the phone with him, sent Mr. Mahon an email saying, we're withdrawing the subpoenas. We have no desire for your assistance. Thank you, you're done. Within 5 minutes of me getting off the phone with him, because he realized that Mr. Mahon was improperly using the subpoena that he demanded that the AUSA give him to seek a stay in this case, and he wanted no part of it. Even then, you gave the federal government an opportunity to come in and say, hey, if you want me to keep this stay in place, let me know. They didn't, because they were never, our parties were never part of the litigation, but for them coming out of Mr. Mahon's mouth. They had nothing to do with anyone in this case, and that's why the government, despite knowing and despite having every opportunity, never entered an appearance to request a stay, because they didn't care about it, they didn't want it. It was Mr. Mahon who wanted it because he wanted to delay it, and in the meantime, we had to seek a contempt order from you because he was going to shareholders, trying to defame the stock, saying they were making false allegations. This all occurred during this period of time where he inappropriately sought to stay. And then it wasn't him, it was us who came back to the court and said, Your Honor, please lift this stay so we can get to the merits. After the court lifted the stay, and I think Mr. Kay said it was January, but I believe it was December, it was 10 months until Mr. Mahon served our clients with discovery. 10 months after this court lifted the stay of discovery. Meanwhile, in that time, the court had to come back and sanction Mr. Mahon's counsel for failing to properly participate, which ultimately the Supreme Court found persuasive that he failed to diligently pursue his case. The Nevada Supreme Court has concluded that and Mr. Kay mentioned that a stay that is a product of misinformation does not toll the 5-year deadline, and therefore under Edwards, to the extent he's trying to make an argument that even though it was only a limited stay of responses to our discovery and you're ruling on our discovery motion, even accepting that argument that would be sufficient in the first place, because it was the basis of misinformation, which the AUSA immediately upon becoming aware of this, withdrew the subpoena. I think that should not toll the statute of timelines. Like I said, under 42A2A, the court mandates dismissal, and it should be done with prejudice. The only other thing, Your Honor, that they didn't address is the only pending claim that the court considered via the bifurcation motion was a injunction that was based upon a contract between Mr. Mahon and his entities and Spin Games. My client is not a party to any agreement and therefore couldn't be enjoined. Even if the court were to set aside all the arguments that Mr. Kay and I have made and give them the most liberal reading of the extension and allow them to bring this bifurcated action, this single claim of an action against Spin for permanent injunction, setting aside whether that can be bifurcated, because you'd have to find a breach in order to enjoin, and a breach is a jury issue. Setting aside all of those issues, it doesn't involve my clients. So therefore, the court can independently dismiss this. I shouldn't have to wait, I guess what I'm saying, Your Honors, I shouldn't have to wait to September to refile this motion, because you can do it under your own discretion. With that, I'm happy to answer any questions.
Okay, thank you.
Thank you, Your Honor.
Honor, I'll be as quick as I can. I know the court's read the pleadings. There are several misrepresentations I need to address. The defendant's motions, it's largely the same motion as the court noted, with a few differences, rely on, essentially, if you look at their reply, I don't know if the court had a chance to look at it Saturday afternoon, but they rely on basically 3 arguments. Okay, they say it wasn't a full stay. They say they go into their motion, in the reply, they say it wasn't even a full stay of all discovery. And you heard it here today in the argument too. It was just a stay of discovery from the full color parties. Number 2, they say Boren doesn't apply because Boren involved a stay where the defendant had moved for the stay. And number 3, they say that this stay was originally obtained through a product of fraud. So those 3 arguments are all based on misrepresentations, Your Honor, of the applicable facts and the law. First, the stay itself was absolutely a full stay. They say in their reply, and I'm quoting here just because I think this is really, it talks a lot, it says a lot about their motion, how they feel about it. They say, page 2, they call it a quote, a partial discovery stay that the full color parties obtained. Page 3, they say it was, quote, a partial stay of only discovery from the full color parties. And then again, also on page 2, line 6, because the stay was only a partial stay of written discovery from the full color parties, it does nothing under warrant to toll the 5-year rule deadline. Well, we pulled up the order, Your Honor. I mean, we didn't attach it to our position because you're not supposed to attach those pleadings that have already been filed under local rules. But it says very clearly, and I just want to quote it for the record, it is further ordered that all discovery, including any further disclosure obligations, is stayed pending further order of the court. It was a complete stay of all discovery. And that's important, Your Honor, because they can't find a case. There's no case in Nevada that says Nevada's 5-year rule, which is arguably one of the harshest, maybe the harshest in the country. And in fact, I'm sure as the court recalls, the Supreme Court itself filed a petition a couple years ago. They said, we want to consider maybe eradicating the 5-year rule. And the end result was they didn't. They modified it a bit. But they say even with that rule, as harsh as it is, the defendants, third-party defendants, want to say, well, you can just go ahead and dismiss the case, even though the entirety of discovery was stayed at the time. Now they understand that that's an argument that doesn't win. So instead they say, well, it was just a partial stay of discovery only from the full color parties. That's completely false, Your Honor. That is not accurate. And that's important also because they cite this California case law. And they're right. Nevada Supreme Court has looked and said, not just in the context of the 5-year rule, but in several contexts. We looked at California. They have a lot of case law, a lot bigger judicial system. So we looked at their case law. However, the 5-year rule in California is very different than the 5-year rule in Nevada. In California, the 5-year rule runs from the filing of each piece of the action. The complaint starts a 5-year rule. A cross claim starts another 5-year rule. A third party claim, such as here, starts another 5-year rule. So the 5-year rule in that case, we didn't file this third party complaint until February 2019. So even with the COVID stay, which they don't dispute applies, we'd have another year to bring it to trial. So if they want to have California law applied, we think that's fine. That would give us at least another year. But even if the court didn't apply that, they want the court to piecemeal apply California law. And they cite this Bruns case that says, well, or seems to say, according to what they bring up as a reply, and that's the first time we saw it. They said, well, under California law, a stay of discovery doesn't toll the 5-year rule. Well, that's not what the Bruns case says. That was a 2011 case. And what the Bruns case says is that a partial stay of discovery doesn't toll the 5-year rule. And I went and looked that up just to see if if I could find a case on it under California. And I did. If I may approach the court, I do have a copy for Your Honor and for opposing counsel. And again, I apologize. We just saw this in the reply. So I pulled that up there. And again, California's 5-year rule is very different than ours. But it does say if you don't prosecute the action, if you're prevented from prosecuting the action, then that time period due to a stay, then that time period doesn't count as part of the 5-year rule. So the court says here, highlighted version here on page 10, under head notes 11 and 12, quote, the term prosecution is sufficiently comprehensive to include every step in an action from its commencement to its final determination. Discovery constitutes a step in the prosecution of the action. So clearly, if you can't complete that step, which is a step in the prosecution of the action, you cannot diligently prosecute the action. And in fact, the Gaines case goes on to talk about a stay that didn't toll the 5-year rule because it was a partial stay of discovery. So that's important. That's why they want to make this out to be a partial stay of discovery only from the full color parties, which it was not. It was very clearly, as entered by the court in the order, a complete stay of all discovery, which interestingly, just to point out the more recent appearances in front of the court, we have tried now for several months. We have been saying we want to bring this case to trial. Let's bring it to trial. In fact, we were fine with the court resolving it all in a bench trial. They want a jury trial part of it. That's fine. They're entitled to that. But every time we bring that up, in fact, I think it was a couple of weeks ago, we were, Mr. Kroll was in front of this, Your Honor, and we're saying, hey, let's reset it for trial. We did the writ, and now we'd like to reset it for trial as the court had already granted a preferential trial setting. And once again, the third party defense said, we can't possibly go to trial when we're requested because we need more discovery. When we filed it way back several months ago, we originally asked for a preferential trial setting. They said, we can't possibly go to trial. We need more discovery. So when we want to go to trial, they say, well, we need more discovery. Discovery prevents us from going to trial. But somehow their argument here is that even though there was a complete stay of discovery, somehow we were supposed to bring it to trial, despite there being a complete stay of discovery, which even the California Supreme Court has recognized is a necessary step in that prosecution. And I'll be brief with my remaining 2 points, Your Honor. They talk about the Bourne case. They say, well, that doesn't help. It was a defendant that sought to stay in that case. The relevant quote from Bourne, though, is independent of who seeks the stay. And it states, quote, any period during which the parties are prevented from bringing an action to trial by reason of a stay order shall not be computed in determining the 5-year period of NRCP 41A. Doesn't say who brings the stay or why the stay is imposed. If there is a stay that prevents a necessary step in bringing the case to trial, then the case is stayed. And that doesn't count for the 5-year rule. Now, the D.R. Horton case, which they conveniently omit, was a situation where a stay was requested by the plaintiff. And the Nevada Supreme Court said, absolutely, that tolls the 5-year rule. Doesn't matter who seeks the stay. If there is a stay, it prevents the case from going to trial, and it is not tolled. Excuse me, the 5-year rule does not run, it is tolled. Finally, Your Honor, this argument about fraud on the court, I mean, to me, honestly, I don't understand it. I had to look back because they cite to a declaration from counsel who apparently spoke to the AUSA. I looked back at that declaration because it wasn't attached, and it states, they said that the AUSA withdrew the subpoenas because Mr. Mahon was weaponizing the justice system or something to that effect. Well, that's not what the email from the DOJ says. It says, quote, I am writing to advise that we are withdrawing all subpoenas that have been issued to you and or any of your company. Now, they try and misconstrue it, and you've heard arguments to counsel, well, that was because they no. There's no indication of anything other than they withdrew the subpoenas. Anything else is a complete fabrication by counsel for self-serving purposes. The reality is the Department of Justice withdrew those subpoenas. That's all they said. We're withdrawing the subpoenas. And the hearsay from counsel acting as a witness is of course inadmissible before the court. Finally, if the court were to consider the Monroe factors, we believe that dismissal without prejudice would be warranted, given the facts that we lay out in our position. Your Honor, we want to move this case forward. We want to get it set for trial. There is a pending motion to reset it for trial within that 5-year rule. If they want to test the merits, let them file a motion for summary judgment. They have a right to do that. But we request that the court deny the motion. Thank you.
Thank you. Briefly, Mr. Kay.
Thank you, Your Honor. Rory Kay for the spin defendants. I agree with them that they want to bring the matter to trial now. 8 years after it was originally filed, 5 years after my client was named in the action. The only problem with it is the 5-year rule doesn't allow you to escape at the stroke of midnight. It requires you to try your case in 5 years. And if we know, I know they have this sudden urgency. We filed our reply, Your Honor, this weekend, so you may not have had a chance to see it. We attached as Exhibit A to that reply the first discovery that the full color parties ever served in this case on my clients. It wasn't until April of 2022. Almost 5 years after this complaint was filed. That's how long they waited to start discovery. You've entered 3 orders compelling discovery in this case. Every single one of them was directed at the full color parties. The original plaintiffs, the shareholder plaintiffs who have since settled out, had to move to compel 16.1 disclosures from the full color parties. We put that in our reply so you could see that. That was way back, I believe, in 2019, if I'm not mistaken, 2 years after the case was filed. We ourselves had to move to compel discovery, which is why this stay ever came about in the first place. They say it was a pending stay of all discovery. That's certainly how they drafted it. But if you look at the underlying declaration from Mr. Mahon, it was a stay of discovery because he didn't want the full color parties to respond to our client's discovery request. There was nothing in there that he didn't want to seek discovery from my clients, if the DOJ had any concern about that. The only pending discovery was discovery that my clients and Mr. Caloiaro's clients had served to him. That was the factual basis for the stay. In fact, if you look at the order in the findings of fact that is provided expressly in the order, we outlined that in our reply. Your Honor, if you want to go back and look at the record on that. I will end with one final point. They argue that it's very clear under Boren, first of all, they say we omitted D.R. Horton from our analysis. I found that surprising considering that it's at page 8 of our reply. Boren has always been a problematic case for the Nevada Supreme Court. It was originally a 1.5-page opinion issued back in, I believe, the 80s or 90s since we've had D.R. Horton. We've had all of these other cases that say it's a factor outside the plaintiff's control that causes the tolling. And D.R. Horton, of course, it was the construction defect pre-litigation mediation statute. I will end with one final point, Your Honor. They made the same arguments to the Supreme Court in the writ petition that they're now making to you. If the law was as clear as they say it is on Boren and D.R. Horton, the Nevada Supreme Court certainly could have granted their writ petition. In fact, it went the exact opposite. Not only did it deny the writ petition, but it found they lacked diligence in prosecuting their case. And so they weren't entitled to basically an order from the Supreme Court commanding Your Honor to set a preferential trial deadline and swear in a witness. So the horse has long been out of the barn. They've had 8 years to try this case. They haven't. There is no discretion on this point, Your Honor, and so we would ask for dismissal under the procedural default with prejudice under NICP 41.
Thank you. Briefly.
Yes, Your Honor, very brief. Your Honor, Mr. Wirthlin kept talking about being prevented from prosecuting their case. They're the ones who filed the stay. They're the ones who didn't want to prosecute their case. They can't file a stay and then tell the court, oh, we weren't allowed to do something. They sought it. They have to bear responsibility for how they chose to litigate this case for the first 8 years of the litigation, right? They're the ones during COVID, even though the time was told, there was still litigation going on. We were still working on the case, still active. They had 8 years to prosecute this case. They've now have to live with the decisions they've made. No one prevented them but themselves from bringing this case to trial. Thank you, Your Honor.
All right, thank you. The motion stands submitted. I'll review them further and issue my ruling.